podium. You have the floor, sir.
Mr. President, members of the court, good afternoon. Professor Sands has shown you that Myanmar's intent to destroy the Rohingya group as such is a manifestly reasonable inference to draw from its pattern of conduct. In fact, it is more than a manifestly reasonable inference. It is the only reasonable inference that can be drawn from that conduct. This is true for at least two compelling reasons upon which I will focus this afternoon. First, the inference that Myanmar asks you to draw from its conduct, that their intention was counter-terrorism, is manifestly unreasonable. This is the only alternative inference that Myanmar offers. In light of the evidence you have heard this week, an inference of counterterrorism would be both counterintuitive and counterfactual. It is simply not reasonable. I won't rehash that evidence. You heard it this morning from my good friend, Mr. Suleiman. You don't need to hear it again from me. I will simply state the 9 conclusions that we say must inevitably be drawn from that evidence. 1, deliberately targeting, shooting indiscriminately at, and massacring thousands of Rohingya civilians, unarmed, unthreatening, and defenseless Rohingya civilians is not counterterrorism. It is the opposite of counterterrorism. It is mass premeditated murder. And this is what the evidence shows Myanmar did systematically in scores of Rohingya villages. 2, inflicting extreme brutality on these civilians by setting fire to their homes and burning them alive, by rounding up men and young boys and killing them execution style, by butchering women and children with bayonets and long knives, by bashing in infants' skulls with rifle butts in front of their mothers before killing them too. This is not counterterrorism. Yet this too is what the UN fact-finding mission found to have taken place in multiple Rohingya villages across Rakhine State. 3, engaging in widespread acts of sexual violence and cruelty is not counterterrorism. Yet it is irrefutable that the Tatmadaw raped and gang-raped hundreds of Rohingya women and girls, including children, in these villages, often torturing and mutilating them by cutting off their breasts and slicing their genitals in too many cases and too many different villages to be coincidental. This cannot be counterterrorism. 4, raising and completely destroying more than 175 Rohingya villages and partially or mostly destroying over 210 more cannot be counterterrorism. Counterterrorism doesn't destroy villages, it protects them by securing them against attack and bringing physical safety and protection to the inhabitants. This is the exact opposite of what the evidence shows Myanmar did. 5, it is not counterterrorism when the Tatmadaw completely ignore and egregiously violated their own rules of engagement, as they did during the clearance operations in scores of Rohingya villages across northern Rakhine State. And they treat the entire Rohingya population, men, women, children, the elderly, the infirm, as an enemy to be destroyed. As Professor Newton, the counterterrorism expert, explains, Myanmar knows what counterterrorism is and what it requires. Its armed forces are not primitive. They are sophisticated, well-organized, disciplined, and obedient to the chain of command. Their rules of engagement reflect modern, universal standards, incorporating the laws of war, emphatic on the need to protect the civilian population rather than target it, yet they might just as well have tossed the rules of engagement into the same fires they set to destroy the Rohingya and their villages for all the attention they paid to them. 6, the clearance operations were so wildly and blatantly disproportionate to the threat that ARSA was said to represent, and involved such an overwhelming number of troops and use of force in relation to that threat that it cannot be reasonably inferred that Myanmar's intent in carrying out these operations was simply to defeat a low-level, poorly armed, and ill-equipped group of rebels who controlled absolutely no territory. Of course, Myanmar had the right to respond to ARSA's provocations, whatever their size or threat. We don't contend otherwise. What we do contend is that it is not reasonable to infer that the Tatmadaw were deployed in such numbers and force in so many Rohingya villages in response to ARSA, especially when the clearance operations targeted the entire Rohingya population in those villages, as if every single Rohingya was, by Myanmar's definition, an ARSA combatant. And these murderous operations were carried out in more than 180 Rohingya villages, as you were shown this morning, in which Myanmar itself admits there was no ARSA presence. If their objective was to defeat ARSA, the means they chose was to destroy all the Rohingya as a group. That is not counterterrorism. 7, the clearance operations in northern Rakhine State differed markedly from actual counterterrorism or counterinsurgency operations carried out by the Tatmadaw elsewhere in Myanmar. Myanmar contends that the same modus operandi were employed in those other regions where they have not been accused of genocide, and it suggests that if similar operations were considered counterterrorism there, it is reasonable to infer that they were counterterrorism operations here. But this is based on an entirely false predicate. Myanmar has not provided the evidence to show that the clearance operations against the Rohingya bear a significant resemblance to its operations elsewhere. And the UN fact-finding mission, whose mandate included investigating and reporting on Myanmar's operations against insurgencies in other parts of the country, concluded that those operations did not bear the hallmarks of genocidal intent that the mission found to exist during the clearance operations against the Rohingya in northern Rakhine State. 8, within Rakhine State, there was an insurgency larger and more threatening than that of ARSA. If the intent of the clearance operations was counterterrorism, why were they not directed at the Arakan army? Why were ethnic Rakhine villages undisturbed. In mixed villages, why were only Rohingya houses and structures destroyed with Rakhine structures left standing? The Arakan Army, which, as you heard, the UN mission describes as a well-trained force that operates under a clear command structure with a significant military armory, differed from ARSA not only in its size and potency, but also, and most significantly for present purposes, in its ethnic and religious composition. As you have heard, the Arakan Army was composed of ethnic Rakhine Buddhists. You've seen the satellite imagery. In the many villages depicted, only the Rohingya areas were burned to the ground, while the Rakhine areas were untouched. Why did the Tatmadaw attack Rohingya civilians and villages, but not Rakhine civilians or villages, when the bigger threat of terrorism was from the Rakhine Arakan Army? The answer is obvious. This was not counterterrorism. This was counter-Rohingya. 9, and finally, as distinguished from the ethnic Rakhine, the Rohingya were despised, discriminated against, and targeted by the Myanmar government based on their race and religion since long before ARSA existed. It is undisputed that Myanmar refused to recognize or accept the Rohingya as a national racial group, excluding them as foreign Bengalis, despite their presence in the country for centuries, and excoriating them as subhuman. They were denied citizenship and nationality, subjected to restrictions on marriage and childbirth to prevent population growth, denied opportunities of employment and livelihood, restricted in their movement and access to food and health care, deprived of basic rights available to other ethnic, racial, and religious groups. They were also regularly subjected to barrages of hate speech, not only as tolerated by the government, but as practiced by it, especially by the Tatmadaw in public declarations by its leaders and on social media, and by its incitement of other racial groups, including Rakhine Buddhists, to despise and rise up violently against them. As publicly proclaimed by the Tatmadaw's supreme commander, the very presence of the Rohingya had long been a problem, an alien group whose procreation threatened to swallow up Myanmar's favored racial and religious groups. And the clearance operations were launched to finally solve this problem. This was not counterterrorism. It was the antithesis of counterterrorism. It was genocide. Mr. President, members of the court, in their written pleadings, the parties have placed two different inferences before you. Only two inferences to be drawn from Myanmar's pattern of conduct. We say the only reasonable inference that can be drawn from the evidence is that Myanmar acted with the intent to destroy the Rohingya as a group, as such, in whole or in part. They say that the evidence permits you to infer that all of this conduct was intended as counterterrorism and nothing more. Mr. President, this is simply not sustainable. It is not reasonable. As Professor Sands said, it is hopeless. The evidence before you not only fails to permit a reasonable inference that Myanmar's intent was counterterrorism, it precludes such an inference. I come now to the second reason why genocidal intent is the only reasonable inference that can be drawn from Myanmar's pattern of conduct. This assumes, quod non, that Myanmar's motive, or at least one of its motives in carrying out the clearance operations in northern Rakhine State, was, as it tells us, to respond to arson. Even if this were a motive, which we do not accept, it would still be the case that the only reasonable inference that can be drawn from Myanmar's pattern of conduct is that its intent was to destroy the Rohingya as a group. This is because the law and your jurisprudence recognize a distinction between motive and intent, as reflected in the judgments of the ICTY, on which the court relied in both the Bosnia and Croatia cases. The point was made most clearly by the ICTY appeals chamber's ruling in the Krnolulak case, citing the earlier Jelicic case, in which it explained that in determining whether the specific intent required to prove genocide is present, there is a, quote, necessity to distinguish specific intent from motive. In particular, quote, the personal motive of the perpetrator of the crime of genocide may be, for example, to obtain personal economic benefits or political advantage or some form of power. The existence of a personal motive does not preclude the perpetrator from also having the specific intent to commit genocide. In the Blashkich case, the appeals chamber further explained that, quote, mens rea is the mental state or degree of fault which the accused held at the relevant time. Motive is generally considered as that which causes a person to act. As far as criminal responsibility is concerned, motive is generally irrelevant in international criminal law. Where the perpetrator is a state, like Myanmar, the motives of its senior officials may also be personal or political and may include, for example, to defeat an insurgent force, such as ARSA. On Myanmar's case, we can proceed on an assumption, quod non, without agreeing that this may have been one of their motives for launching the clearance operations at the time they chose. But there is no inconsistency between Myanmar or its officials having this motive and at the same time having a specific intent during the clearance operations while committing the actus reus of genocide to destroy the Rohingya as a group, either as an end in itself or as a means of defeating ARSA by depriving it of its potential base of support. The motive to defeat ARSA can thus exist alongside a specific intent to destroy the Rohingya group, or a substantial part of it, manifested in the manner and means by which the clearance operations were carried out against the civilian population. Indeed, the Tatmadaws' putative motive and specific intent were complementary. The ostensible object of defeating ARSA was pursued by means of the deliberate destruction of the Rohingya group as such. The stated objective served as a convenient facade behind which the Rohingya group as a whole could be targeted for destruction, as the evidence shows it was. Now, this is not the first armed conflict in which a warring party seized the opportunity under cover of combat to target for destruction a despised racial, ethnic, or religious minority, which it treated as an enemy population to be destroyed. On Monday, I recalled Judge Cansado Trindade's prescient words from the Croatia case, which ring as true as ever in the circumstances of this case. Quote, "The perpetrators of genocide will almost always allege that their actions were taken pursuant to an ongoing military conflict." They're not very original. Yet genocide may be a means of achieving military objectives, just as ready as military conflict may be a means for instigating a genocidal plan. The ICTR considered this very issue in the Akayesu case, about which my colleagues have spoken. The trial chamber there faced the question, quote, whether the tragic events that took place in Rwanda occurred solely within the context of the conflict, which was between the Rwandan armed forces and the Tutsi-led Rwanda Patriotic Front, or RPF. The chamber found that these events did not take place solely within that context, finding that, quote, the genocide did indeed take place against the Tutsi group alongside the conflict. The tribunal explained, quote, the massacres which occurred in Rwanda in 1994 had a specific objective, namely the extermination of the Tutsi, who were targeted especially because of their Tutsi origin, and not because they were RPF fighters. In any case, the Tutsi children and pregnant women would naturally not have been among the fighters. Likewise, the UN fact-finding mission emphasized the Rohingya civilian villagers of northern Rakhine State, including, but not limited to, pregnant women and children who were killed by the Tatmadaw, were targeted because they were Rohingya, not because they were ARSA fighters. Another example can be found in the Karadzic case, in the appeals chamber of the International Residual Mechanism for Criminal Tribunals. Karadzic, the leader of the Bosnian Serbs, appealed his conviction of genocide for his role in the Srebrenica massacre. He claimed in both the trial and appeals chambers that certain statements attributed to him demonstrated that he had military objectives, thus, in his view, ruling out genocidal intent as the only reasonable inference. The appeals chamber rejected this argument and upheld his conviction. Quote, Karadzic merely provided an alternative interpretation of the evidence, but failed to demonstrate that the trial chamber's interpretation of his statement or its reliance on it in establishing his intent was unreasonable. Belgium, in its intervention in these proceedings, cited a decision by a German court, the Higher Regional Court of Frankfurt, in the criminal prosecution of an ISIS fighter for participation in the genocide of the Yazidis in northern Iraq. The court there found that genocide was an interim goal in the Islamic State's broader military campaign aimed at establishing a caliphate. For Belgium, the case illustrates that genocidal intent may be present, quote, even when the ultimate military objective with which the intent coincides goes beyond the immediate destruction of the protected group. Myanmar's clearance operations, which it claims were aimed at ARSA, did not succeed in defeating ARSA, which still exists. And in fact, ARSA is now allied with the Tatmadaw against the Arakan army. This gives new meaning to the concept of strange bedfellows, and it reflects the ultimate cynicism of both members of this unholy union. But the clearance operations did fulfill their intention of destroying the Rohingya in substantial part as a group within Myanmar by killing many thousands of them, clearing them out of hundreds of their villages, preventing them from returning, and forcing hundreds of thousands to flee to safety in Bangladesh, where they remain without any foreseeable hope of repatriation in the squalid and life-draining conditions of the world's largest refugee camp. Mission accomplished. At least that is what the Tatmadaw and its supreme commander and head of state, Senior General Min Aung Hlaing, and his criminal accomplices could smugly conclude about the success of their carefully planned clearance operations. Mr. President, the court itself has recognized the difference between motive and intent in its own reasoning and by its reliance on the relevant ICTY judgments in both the Bosnia and Croatia cases. In Bosnia, the court stated that the intent to commit genocide is, quote, to be distinguished from other reasons or motives the perpetrator may have, end of quote. It found in that case that the Serb perpetrators massacred Muslim men and boys at Srebrenica with genocidal intent, despite finding that, quote, an essential motive of much of the Bosnian Serb leadership to create a larger Serb state by a war of conquest, if necessary, did not necessarily require the destruction of the Bosnian Muslims and other communities, but their expulsion. Judge Bandari, recalling the Bosnia case in his separate opinion in the Croatia case, agreed that, quote, genocidal intent may exist simultaneously with other ulterior motives. And he called attention to the ICTY's finding in Popovic that the massacre at Srebrenica, quote, the massacre at Srebrenica enclave was in part motivated by the strategic advantage of uniting a greater Serbia. He went on to observe, quote, never was it suggested that this tactical motivation precluded the attack from possessing genocidal intent. In the Bosnia case, as you know, the court found that outside of Srebrenica, an intent to commit genocide was not the only reasonable inference that could be drawn from the Bosnian Serb forces' pattern of conduct. This was because the court found that it could also be reasonably inferred from the evidence in that case that the intent of those forces was the expulsion or ethnic cleansing of Muslims from Serb-occupied territory rather than their destruction. However, the court made a point of explaining that where the evidence warrants, it can be concluded that acts of ethnic cleansing have been committed with genocidal intent. Quote, this is not to say that acts described as ethnic cleansing may never constitute genocide, if they are such as to be characterized as, for example, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part. That is to say, with a view to the destruction of the group as distinct from its removal from the region. In the present case, as we underscored on Monday, Myanmar does not defend itself by arguing that its clearance operations were for the purpose of ethnic cleansing or the removal of the Rohingya group from the region they inhabited. It argues that its purpose in carrying out these operations was counterterrorism. But the lessons from the Bosnia and ICTY cases are just as pertinent. What they tell us is whatever the motive for the perpetrator's actus reus, if the particular circumstances or pattern of conduct show that this act or these acts were carried out with specific intent to destroy the group, genocidal intent will be the only reasonable inference. On this basis, the only reasonable inference to be drawn from the killings, burnings, extreme brutality, sexual violence, destruction of villages, and massive forced displacement of the Rohingya population carried out by Myanmar in the name of counterterrorism must be that Myanmar acted with genocidal intent. The Croatia case is also pertinent. There, as in the Bosnia case, the court found that genocidal intent was not the only reasonable inference that could be drawn from the Serb forces' pattern of conduct. Instead, it concluded that the acts constituting the actus reus of genocide, quote, were not committed with the intent to destroy the Croats, but rather with that of forcing them to leave the regions concerned so that an ethnically homogeneous Serb state could be created. However, here again, the court accepted that genocidal intent could have been established if the evidence had shown that, quote, the forced displacement was carried out in circumstances calculated to result in the total or partial physical destruction of the group. Thus, even where the perpetrator's motive is forced displacement or ethnic cleansing, a finding that it acted with genocidal intent is not precluded if the intent of the perpetrators at the time they carried out these acts was to destroy the group. The joint interveners, Germany, France, Canada, Denmark, the Netherlands, and the United Kingdom, make the same point, that forced displacement can be carried out in circumstances that demonstrate genocidal intent. Citing the ICTY, they say, in relation to Article 11b of the Convention, forced displacement may, depending on the circumstances of the case, inflict serious mental harm by causing grave and long-term disadvantage to a person's ability to lead a normal and constructive life so as to contribute or tend to contribute to the destruction of the group as a whole or a part thereof. As we made clear in our written pleadings, we agree. In fact, we have already said the massive forcible displacement of the Rohingya group, with hundreds of thousands forced to flee across the border to Bangladesh during and in the wake of the clearance operations that destroyed or partially destroyed more than 390 Rohingya villages, was carried out, along with the other atrocities attendant to the clearance operations with the specific intent to destroy the Rohingya as a group within Myanmar. What the jurisprudence shows is that the perpetrator's motive may be forced displacement or ethnic cleansing to establish an ethnically pure state, or it may be counterterrorism to defeat an insurgency. But motive, whatever it is, does not tell us whether genocide has been committed. That depends on the intent of the perpetrators in carrying out these actions and whether the particular circumstances or the pattern of conduct manifests a specific intention to destroy a protected group, as such, in whole or in part. What this means is that it is insufficient for Myanmar to tell us that its motive for launching the clearance operations against hundreds of Rohingya villages was counterterrorism, even if such were the case, quod non. That motive, even in the unlikely event that the court were to suspend disbelief and allow itself to be persuaded that it was present, does not displace or disprove the existence of genocidal intent. Far from it. On the evidence before the court, evidence which, as you have heard, is compelling and overwhelming, there is only one reasonable inference that can be drawn regarding Myanmar's intent to destroy the Rohingya group as such. Mr. President, it is worth observing that the court has used different linguistic formulations to express this standard of proof, which has come to be known as the only reasonable inference standard. In the Bosnia case, for example, the court said, in respect of genocidal intent, for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent. In the Croatia case, the court framed the question thusly: is there a pattern of conduct from which the only reasonable inference to be drawn is an intent of the Serb authorities to destroy in part the protected group? Then, in explaining its approach to answering this question, the court said that the court will examine first whether the acts committed by the JNA, Yugoslav Army, and Serb forces form part of a pattern of conduct, and if so, it will then consider whether an intent to destroy the Croat group is the only reasonable conclusion that can be inferred from that pattern of conduct. So we see from these two cases three different ways of describing the applicable standard of proof of genocidal intent. Evidence that, quote, could only point to it, evidence from which it is, quote, the only reasonable inference to be drawn, and evidence from which it is, quote, the only reasonable conclusion that can be inferred. To be clear, we are not suggesting that there is any uncertainty about what the standard of proof is. There is no uncertainty. The different formulations in the Bosnia and Croatia cases, in our view, all describe the same standard, the only reasonable inference standard. The court has been very clear about this, in our view. But the different words used by the court to describe the standard help us to better understand what it means. By only reasonable inference or only reasonable conclusion, we understand that other inferences or conclusions, besides an intent to destroy the protected group, may be possible or plausible, but they will not prevent a finding of dolus specialis unless they are reasonable. There may be other points on the compass, but they are irrelevant if the arrow, quote, could only point to genocidal intent. We say, based on the evidence, that counterterrorism is not even a possible or a plausible inference to be made in this case. It is not even a point on the compass. But even if it was, it would not prevent genocidal intent from being the only reasonable inference, because counterterrorism is by no means a reasonable inference. The court's approach to inferring intent works. It works because it understands and takes account of human nature. Science teaches us that human beings rarely act for one single reason. Freud explained that any human behavior is typically caused by multiple interconnected factors. Human motivation, in his view, is driven by, quote, a seething cauldron of conflicting motives and desires, rather than any single reason. The court's task, as defined in its jurisprudence, is not to dive into that cauldron and psychoanalyze the perpetrators, in this case the Tatmadaw, but to discern from the particular circumstances or from their pattern of conduct whatever else may be seething among their conflicting motives. They acted with a specific intent to destroy the Rohingya as a group, in whole or in part. In its intervention, the Democratic Republic of Congo cites to a 2024 treatise entitled The Genocide Convention, an article-by-article commentary authored by Professors Tams, Burster, and Schiffbauer. In it, the distinguished authors observe that, quote, no monocausal psychological relationship is required to prove dolus specialis, and, quote, the victim's group affiliation may be one reason to act within a bundle of motives. They go on to explain, quote, within the complex realm of human decision-making, even the perpetrators themselves will often be incapable to discern the extent to which their actions relied on one motive versus another within a multitude of motives. All the more, a court would have tremendous difficulty in attaining adequate clarity regarding the significance and hierarchical structure of the motives at play. This is why we submit criminal law and international law distinguish between motive and intent. Thus, even if within their own seething cauldron, the Tatmadaw harbored a motive to combat ARSA, which we say Myanmar has not proven, it would be irrelevant to the central issue before the court, whether they acted with the intent to destroy the Rohingya as a group in whole or in part. In sum, what both the court's jurisprudence and our knowledge of human behavior teach us is that Myanmar can incant the word counterterrorism all it wants, but there are no magic words that can turn fiction into reality, or in this case, turn its proffered inference, which is completely belied by its own conduct during the clearance operations, into a reasonable one. We submit that the compelling evidence you have heard this week and have seen in our written pleadings should leave you with no doubt that the only reasonable inference, the only reasonable conclusion you can draw from it is that Myanmar's armed forces acted with the specific intent to destroy the Rohingya as a group. As the court said in the Bosnia case, quote, where these requirements are satisfied, the law must not shy away from referring to the crime committed by its proper name, genocide. Mr. President, before concluding, I wish to make a correction to something I said in my presentation Monday afternoon. In discussing the witness statements submitted by the Gambia, I said that of the 48 statements, not including those supplied by the IIMM, 14 had the names of the witnesses redacted for their protection at their request. The correct number is 30. I apologize for the error and for any inconvenience this might have caused the court or the registry. This, Mr. President, members of the court, concludes my presentation this morning, and it also concludes the Gambia's presentation for the day. I thank you again for your kind courtesy and patient attention, and I bid you a good evening.
I thank Mr. Reichler, whose statement brings this sitting to a